Singapore's highest courts are currently adjudicating modern animal welfare cases using a conceptually incomplete legal foundation. The state imposes highly stringent regulations on dog ownership. Pet owners face severe financial penalties for cruelty and duty of care failures, including fines up to 15,000 Singapore dollars and potential imprisonment. Ownership limits are both explicit and strictly enforced. In HDB flats, public housing units where the majority of Singaporeans live, residents are legally capped at a specific number of pets, and certain breeds are entirely prohibited. For these specified dogs, the state layers on additional public safety conditions. Owners must microchip their animals, secure high-value insurance policies, and adhere to strict behavioral controls when moving through public spaces. The state treats these animals with a high degree of regulatory seriousness and protection. Yet the primary legislation conspicuously fails to declare exactly why these beings warrant such intensive safeguarding. The primary legislative vehicle for animal welfare in the country is the Animals and Birds Act of 1965. This structural breakdown highlights a glaring omission. There is a complete absence of explicit statutory recognition that animals are sentient beings. This textual silence creates distinct friction, forcing lower courts to stretch existing interpretations just to handle cases involving non-physical neglect or psychological abuse. This omission leaves the law conceptually thinner than its actual administrative functions. Without a clear legislative compass, the judiciary has to operate in a gray area, pulling modern welfare concepts out of a mid-20th century text. We now have a clear contemporary scientific consensus on mammalian conscious experience. Documents like the New York Declaration on Animal Consciousness confirm that these animals experience subjective states. This 5-part matrix shows the 5 domains model, an evaluation framework used in animal welfare science. It demonstrates how nutrition, physical environment, health, and behavior all feed into the central, culminating assessment of an animal's mental state. This scientific reality directly connects to the 2013 District Court decision in Public Prosecutor versus Ling Chung Yi Roy. The case involved a dog subjected to chronic environmental neglect, kept isolated on a balcony for extended periods. In that case, Judge Ng Keng Hong made a crucial legal distinction. He ruled that proving unnecessary suffering does not strictly depend on the animal being physically sick or visibly injured. The Roy decision successfully moved Singapore cruelty law away from bodily reductionism. It proved that the courts are already actively attempting to recognize psychological distress, even without explicit statutory help. In 2025, the High Court elevated the jurisprudential stakes with a sentencing appeal known as Public Prosecutor v. Lin Peng Li Bari. In paragraph 24 of the judgment, Justice Vincent Hung specifically classified the animals protected by the Act as a uniquely vulnerable class of victims. The court then went further, explicitly using the exact term sentient creatures to describe the victims. The judicial language is now fully aligned with biological reality. The High Court is actively speaking a language of sentience that aligns perfectly with modern science. Yet the primary statute remains awkwardly silent, leaving this legal evolution dangerously reliant on judicial discretion rather than a clear democratic mandate. This schematic of the Act shows a legally orthodox solution. Inserting a narrow welfare principles clause within Part 4 addresses the gap directly. The boundaries are precise. It does not grant legal personhood to animals, collapse property law, or override public safety regulations. The UK's Animal Welfare Sentience Act of 2022 provides clear proof that explicit sentience recognition is a standard, manageable feature of modern common law. We also see this in Article 13 of the TFEU, the Treaty on the Functioning of the European Union, forming the EU's constitutional basis. It utilizes sentience as an interpretive principle of governance without causing legal chaos. Explicitly codifying sentience is a deeply bounded evolution, already proven safe in pure jurisdictions, rather than a radical activist disruption. The clause formally recognizes psychological suffering, but strictly demands verifiable scientific proof, preventing rulings based on speculative compassion. Right now, prosecutors rely on piecemeal case law. A firm statutory directive would clearly codify what the courts and the AVS already operationalize daily. The AVS is the Animal and Veterinary Service, the state agency responsible for animal health and welfare regulation in Singapore. codifying animal sentience does not make Singapore's legal system eccentric or overly emotional. It simply aligns the statute book with the jurisprudential reality the courts already recognize, making the law accurate.